Thank you, sir. Bob Norard, on behalf of the appellant Robert Joe Long, I've reserved 3 minutes for rebuttal. To state the obvious, we're here on a post-conviction case where the key issue in this case revolved around Mr. Long claims regarding ineffective assistance to counsel as it relates to the entry of his plea and then maintaining a plea agreement. What I think we need to look at in cases like this, that from trial court to appellate court when I deal with these issues, is that it's so easy for attorneys and judges to forget that those people standing before a judge being asked questions on what are in reality complex legal issues are lay people who have not been through years and years and years of doing this. Trial judges can recite plea colloquies in their sleep. Defense attorneys know the things that their clients need to know when it comes to a plea.
Well, Mr. Norard, in this case, correct me if I'm wrong, he first moved to withdraw after entering it, he moved to withdraw the plea. The trial court actually allowed him to withdraw his plea. And then the next morning, again, he elected not to. So we don't really, this isn't, I mean, and I realize there are other issues, but could you address the fact that did that not happen as far as this case is concerned, or is that another part of when he pled guilty?
No, ma'am. This is part of what happened.
So he did, in other words, he pled and then he asked to withdraw it. The judge
Correct.
allowed it, and then he came back and he pled again.
Right. But I think what's critical that you have to look at in terms of the facts here is that Mr. Long, shortly before a penalty phase was about to begin, overheard his attorneys talking about the fact that he had something about a waiver of a confession issue. That was something he never contemplated, didn't understand, didn't know about. So after hearing on that limited fact situation about the waiver of the appellate rights on the confession issue.
Can you back up for a second? What do you mean he overheard his attorneys talking about the waiver of the...
The testimony of Mr. Long at the evidentiary hearing in this case is that he was in the holding cell prior to the proceedings getting ready to begin, that his attorney, Brian Donnerly, and Charlie O'Connor were talking to each other. He overheard something where they were saying something about the confession issue, which prompted him to ask them questions about what it was they were talking about. And that was when it was realized that his appellate rights were being implicated in that area, which prompted the motion to try to withdraw the plea and the hearing on that matter.
That overheard conversation, when in relation to his plea, was that before or after?
This was months. His plea was in September of 1985. This was when the penalty phase was getting ready to start several months later.
But you're giving his version, which there was an evidentiary hearing on this issue, was there not?
I'm not just, well, it's not just his version.
But I'm asking you, the judge on this issue, the ineffective assistance of his counsel in counseling him about the plea, had an evidentiary hearing, and there was also several times, because the defense lawyer had passed away, the judge found Mr. Long's testimony about when he knew that he was waiving his appellate rights not to be the credible version. Is that correct?
Well, obviously the standard here is we have to look and see if the trial judge had, competent, substantial evidence on which to base.
All right. So, but what I'm saying is, when you give, this is what happened, and you're giving Mr. Long's version of what happened,
which is corroborated by Tony Webb, the investigator.
But when you're giving it, we still have to look, and you said is what the trial court made a determination as to what the credibility was and made findings, and we have to give those findings deference, correct?
That's correct.
Okay.
But it still has to be based on competent, substantial evidence. we have a situation where Craig Ulrich, one of the surviving attorneys, talked about the situation. We have the testimony of Tony Webb, the investigator who was part of some of these negotiations. We have Mr. Long's unrebutted testimony that also is corroborated by history. After his case came back on a retrial, he testified to virtually the same things. Within days after this plea, he was writing letters to his attorney about his mental state. Within a couple months after this plea, he's writing him a letter saying, I know I waived this, but what does that mean? And the unrebutted evidence in this case is that nobody ever sat down with Mr. Long, went over that plea agreement from beginning to end, explained to him, this is what this means, these are the rights you're giving up, this is what is being taken off the table by your entering the plea.
But didn't the judge's colloquy on at least 2 or 3 different occasions, he specifically asked him these questions, and Mr. Long responded that first said, well, my appellate, but he was talking about the penalty phase, and then the judge went on to clarify, say, I'm talking about as to not to the penalty phase, but to everything else, including the confession. And he said, yes, I understand. I mean, and I thought also Mr. Webb also indicated that he was present when, in fact, these end of his waivers was explained to him by Mr. Connors. Mr. Connors did not testify in the post-conviction hearing because he's dead, right?
Okay.
So conveniently, we can...
I've got a lot of questions on the table. I'm not getting the chance to answer, guys. I'm sorry, but I've not even answered your first question. I've got an answer for it. I can answer your questions. Mr. Webb, go back and read his testimony. He said that there were some discussions about a waiver, but he also said that he believed Mr. Long thought he could appeal. That's what Mr. Webb testified to. The plea colloquy, I mean, it'd be nice if the attorneys didn't do their job, that a plea colloquy could clean up everything. But I'm looking at the plea colloquy. I've got it right in front of me here. The judge says, you're giving up your right to appeal any issues in these matters, Mr. Long, on any issue, question mark, on any issue. Yes, sir. Mr. Long, I wasn't aware of that. The judge then gives him a fairly long comment that I'm not going to quote here. Mr. Long kind of says, okay, and then the judge says, obviously, maybe I misworded it. Anything that's behind it, behind us. I mean, here's a plea colloquy where the judge himself says, I'm miswording things. And then you have the prosecutor piping up on any issue as to, I believe, this particular plea agreement. If any appellate issues arise in the second phase, you can appeal that. Does a defendant know that if a confession came up in his plea thing, that that's not something he could raise?
Mr. Norard, there was a hearing, and this has gone on for many years, and that is this attempt to attack his guilty plea. There was a hearing in February of 1989. At that time, he testified he never read the agreement, but he acknowledged that Judge Griffin went over the plea agreement with him, and that he decided not to withdraw the plea when he was given the opportunity because he wanted to limit the potential exposure to the death penalty, and he did not want to go through 8 trials. Just so we're clear here, this is not even a run-of-the-mill death penalty case where there is one case and you're making a decision whether you're going to avoid the death penalty or not by pleading. He had a potential exposure of 8 pending cases where the idea was that he would there was agreements about those other 8 cases. So is that testimony where he said that he wanted to limit his exposure to the death penalty and that he didn't want to go through 8 trials? Is that in the record? Am I misreading that? Can you tell me about that?
You're not misreading that, but I think you can't take it out of context of the overall
But
testimony.
can we take it out of context that a man who is facing, how many, 8? 8 potential death sentences makes a decision to plead guilty to one, to avoid having to go through 8 trials where he has allegedly, in those other cases, committed terrible murders, and that it's not for, unless somebody is close to being in another world, that's not like, what lawyer wouldn't advise that that's probably the best deal he's going to get? I mean, you know, that's the context that I'm still sort of wondering. You know, I appreciate your advocacy. How do you take that situation, which is what the state was giving up, out of context?
Yeah. It's not like we're talking about, you're looking at a possibility of 1 5-year sentence and 8 more 5-year sentences. We're talking death sentences. You can kill somebody once. It doesn't matter how many death sentences you have. If you get one, you're going to be dead. He was already on death row for a case in Pasco County that was on appeal, where the confession issue was being litigated. In the Hillsborough County case, gee, would anybody want to go through 8 trials? I think a circuit judge, if somebody walked in Monday morning and I said, we just wiped 8 trials off your docket, would be happy.
But the reality is, from the defendant's perspective, the reality is that being exposed to one circumstance in which you can hope to avoid the death penalty, but you're subject to it, you've got one decision point here, is very different than being exposed to the death penalty serially in 8 proceedings. There's a greater chance that you're going to end up with a death penalty if you're exposed to it in 8 different proceedings than if you're only exposed to it once.
Well, he already had one.
Well, I understand that, but he was hoping that would go away. I understand.
Now he's looking at a second one. And what you have to understand what he was weighing that against. Yeah, I don't want to go through 8 trials if I don't have to, but if that suppression of the confession worked in the Florida Supreme Court, which it did in his Pasco County case, the state would have had no cases. His case is over in Pasco County. And he knew that that's what he was going to be potentially given up, was, you know, it wasn't just 1 death sentence, 2 death sentences, 8 death sentences. It was, do I give up these important appellate rights, you know, and throw the dice on one case that I might get a life sentence? This was an either or. This was a very tough decision for Mr. Long, which goes back to what you asked me in your very first question. The judge gave him the opportunity to withdraw the plea. At the time that the conversations occur in the back room, it was a discussion about the relative merits of that appeal in Pasco County based on the suppression of the confession. He's got lawyers, his lead lawyer, Charlie O'Connor, saying that this court, your predecessors, would change the law rather than grant Bobby Joe Long relief. The idea that a court, because of a particular fact pattern, would just throw out their precedent and chuck it out the window. That's the advice he was getting from his other attorneys. Craig Aldridge's testimony that the trial judge in her order totally overlooked talked about the responsibilities of an attorney in a capital case in advising the client on the consequences of his plea. And it simply did not happen in this case. A lay person with serious mental health issues, a lawyer that he had delusions about, a lawyer that him and his client didn't get along, didn't do the most basic things that Craig Aldridge described an attorney does. I don't care if it's a grand theft auto or a first-degree murder. You sit down with your client and you go over the plea agreement and you make sure they understand what they're waiving, the significance of what they're waiving. That simply did not happen in this case.
What is the second prong? What do you have to establish on the second prong of under Hill versus Lockhart, and then our precedent.
That since relatively shortly after this plea agreement, which Mr. Long testified, the only reason he said, I'm going to hold it right now, is because he knew he was getting a new lawyer and was going to talk to that lawyer about moving to withdraw it. But he's been fighting this since 1985, trying to now get out of this plea agreement, despite even back in 89 when Mr. Frazier's telling him, hey, if I file a motion to withdraw and you get out of it, you're looking at these 8 trials. And Mr. Long said, I don't care.
So that's all. You only have to establish not whether he'd be successful, just that he would have gone to trial.
Oh, that's clearly the law. Absolutely, 100% clearly the law. And, you know, here's this thing that just blows my mind. In 1983 and 1989, the black letter law in both state and federal court was an equivocal confession. A counsel was going to bounce that confession. I understand the law has changed given some of the changes in federal law, some of the changes that have occurred in state court law, obviously. But at the time he was begging Mr. Frazier, at the time he was forced to waive the right to try to withdraw that plea, that confession would have been gone. And that's the right he gave up, so that instead of maybe having a judge stand in front of a judge 8 times and say, I'm sentencing you to death, it would only have been 2 times.
What is the main part of the state's case, in this case and the others, his confession?
Yes, ma'am.
There's no physical evidence that...
The only physical evidence was carpet fibers, and the state's expert at the time was an agent by the name of Malone that I know you guys are probably well familiar with, FBI agent Malone. Some carpet fibers. That was about it.
Hair too, I believe.
Yeah, and Mr. Malone was the proponent of that evidence. And I'm sorry, you have some hairs that are consistent, some fibers that are consistent, nothing else. We'd be arguing a JOA years ago if that's all they had. And in fact, that's what ultimately resulted and happened in Pasco County. Sam, past my time. Got about 2.5 minutes left, but thank you very much.
May it please the court, Assistant Attorney General Stephen Ake on behalf of the state of Florida. The post-conviction court properly denied this claim of ineffective assistance of counsel, and in doing so made a credibility determination that Justice Pariente spoke about earlier, in that although the defendant testified that counsel did not explain or review the plea agreement with him, the court finds his assertions are not credible. The state would submit that that is supported by substantial and competent evidence. Counsel says that it's unrebutted that his testimony, Long's testimony, was that nobody explained this, and to the contrary. We have in the record his lead counsel, Charles O'Connor's testimony in 1989 in front of Judge Lazara, where he does say that he went over this. The testimony from Mr. O'Connor...
When you say this, let's just focus on, I guess the main this that we're focusing on is whether he was aware that he would forfeit his appellate right to contest the voluntariness of the confession, right? There are a lot of cases where defendants move to withdraw pleas and it's kind of amorphous and, it's not, but here he's always focused on that very specific issue. So what is the testimony or evidence in the record that particular aspect, that is, I will not be able, which is, of course, part and parcel of what we as lawyers and judges understand. I mean, there are some plea agreements, right, where you expressly reserve your right to appeal, right, confessions or other sorts of things. So what does the record show about that aspect of when he was specifically told about you are waiving your appellate rights to appeal the confession voluntariness?
Well, you have, starting with Mr. O'Connor's testimony in 1989 in front of Judge Lazara, where he said he explained that to him. You have the plea colloquy in September of 1985 in front of the judge when he initially entered the plea. Then he comes back in December.
Was it there, on that colloquy, was it specifically said you will be waiving your appellate rights?
They went through it number by number, Your Honor, in that September hearing, and they started as, it's a 3-page plea agreement, and they went through each number and discussed each of these on the record.
The actual, so the actual plea agreement, not just the colloquy that we would see.
Right.
In,
In September, when he first pled, the testimony was, now Long says he only looked at this for 5 or 10 minutes before he ever actually entered the plea. That's his testimony. Mr. O'Connor and the private defense investigator, Mr. Webb, testified that they had gone to him beforehand and explained it to him.
but I thought there was some part about where that aspect of the plea agreement wasn't in there at the time they went to the jail.
It was not. It was orally done. At that point in time, all they had was an oral representation of what the plea agreement was.
Okay, so what is the written part that was actually, and I understand what Mr. Norard's saying, defendants don't listen to what's going on in
Right.
court, but you know what? they have to listen, and so, you know, and what was explained to him
Well,
at that
Your Honor,
time?
like I said, in September when he first did it, they did a plea colloquy and discussed that particular point. Each paragraph, there's
And
only 6 of them.
what does it say about that point?
It says, defendant waives his right to contest the admissibility of any statements he has given law enforcement, and such statements are admissible at the sentencing hearing only, in this case, the one that he was pleading to, that they were going to have the penalty phase for.
Okay, so it
And
wasn't
then-
just a general, I'm giving up my appellate rights. It was actually specifically told that he was giving up his right to appeal the confession. Is that
That's-
correct?
Right, that's in September. But then, if there's any confusion in the defendant's mind, which he says there is, it comes back in December at the penalty phase. They've already picked a jury. They spent 2 days picking a jury. And I would submit, if you go
By
back...
then, he's already entered his plea, so I guess
Right.
we're talking about, the issue is,
Well,
at the time he entered his plea, did he know what he was entering? So I'm not
Correct,
sure
Your Honor,
why
but-
we'd go to what he might have learned afterwards.
Well, the reason we do is because he was given the opportunity to withdraw that plea, and he, again, opted to
Okay,
continue on with
that's the
it.
part that I was
That's
asking.
in December. That's when they, and I want to point out to this court what I think is important in that December 11th and 12th hearings that are in the record. In December 11th, they've picked a jury for the penalty phase. They've gone 2 days on jury selection. Counsel, or Mr. Long, is upset because his mental health expert is not there, and that's why he's wanting to withdraw his plea. He throws in the confession thing additionally. I grant that he definitely says that, but his main reason is that Dr. Morrison is not there. And in fact, he says, if Dr. Morrison was here, I'd continue on with it. We'd go through the penalty phase. But be that as it may, he does say that was misunderstood what he was giving up as far as the confession went. So the court gives him 24 hours. They have a huge discussion between not just his Hillsborough County public defenders, but also his Pasco case, which counsel here represented him in the Pasco case, and he was there. The Pasco attorneys are telling him that he shouldn't give it up, that he should fight it and have a motion to suppress because that's what they did in Pasco. And the Hillsborough attorneys are saying, hey, we've worked out this great deal for you where we got your exposure to these 8 cases down to just 1. And we have this great penalty phase where we're going to present mitigation, and we think we might be able to get you a life recommendation. So that's his Hillsborough attorneys are giving him one set of advice, and the Pasco attorneys are giving him another set
This
of
is in
advice.
this 24-hour
This
period?
is during the break in between. After December 11th, the judge says, Mr. Long, you can withdraw your plea, and they request a continuance until the next day. So they go in, they meet in this meeting room and discuss this. After that lengthy meeting, which everybody testifies was about an hour long, Mr. Long goes back to the jail and calls another attorney that he had dealt with on a pro bono basis, and she advises him too.
Now, wait, that's the resource center attorney?
Right. I forget her name.
I thought her advice was...
To not do to withdraw the plea and pursue the motion
Okay,
to...
so you had that lawyer saying you should fight the confession.
And the Pasco lawyers
Saying that,
Yep.
and then the Hillsborough lawyers...
saying the opposite, saying you should do this plea deal. And Mr. Long comes back into court, and they again do another colloquy the next day on December 12th, where that's the whole issue, is giving up the confession thing. I mean, to say that he didn't understand it is ridiculous, because that's all he testified. That's all I've been thinking about for the last 24 hours.
Well, is it a claim that the Pasco lawyer the Hillsborough lawyer, Mr.
Hillsborough.
O'Connor,
Right.
gave him, because this is an ineffective assistance. We don't have an issue that the judge did everything he was supposed to do
Right.
here, because we decided that long ago on direct appeal, that the advice was sufficient advice, that a reasonable lawyer would have advised him to go to trial? Is that one of the claims
real
here?
allegations dealt with that he was under medication and that he had brain damage and mental infirmities that prevented him from understanding this, and that counsel should have taken greater steps to explain it to him. And of course,
So
those
it's
were
not
rejected.
an issue that any reasonable lawyer, again, if you had something where there was almost no evidence and a lawyer just said, plead guilty anyway,
Right.
that's not, that's not the claim?
No, this is, I was under medication and I had this mental health issues that prevented me from understanding this. And of course, we had the hearing on that, and that was refuted by the testimony of everybody that he was not on medication at the time, and that although he had mental mitigation presented at the penalty phase, even the defense expert said it didn't affect his ability to understand what he was doing as far as the plea agreement went. So the court, in rejecting this ineffective claim, said no deficient performance. We have Charles Connor testifying that he explained it. We have the investigator stating that Charles Connor explained it to him at the jail. And then we have the record, the plea colloquy itself, that shows that in this court, I'd remind this court, this came up twice before this court, and on the face of the record, this court said there's no ineffective assistance of counsel. He had a voluntary, knowing, intelligent waiver of that plea. He knew what he was doing, and I would remind the court of that. But as to the prejudice prong, the court also denied that and said there's no way that he would have withdrew his plea and proceeded to trial. Mr. Long has made it abundantly clear that he does not want to be in Hillsborough County for any reason. He didn't show up for the evidentiary hearing. He did it by telephone. Based on all the factors that were involved in this case, there's no way that he would have gone to trial on 8 different cases where he was facing the death penalty. And I would point out that counsel said that, basically the confession was dispositive and that there wasn't any other evidence. That's incorrect. There's no way in this record that we know what the evidence was as to these other 8 cases. The only allusion to the evidence was Charles O'Connor at that 1989 hearing saying, I'm aware that the state had other evidence in the nature of carpet fiber, hair, tire tracks, and what have you, but that's all we know about those other cases. So there could have been an abundance of evidence for all the record shows as to these other 8 cases, but counsel made a tactical decision. You're facing 8 death penalty cases here. We got you a deal where we're going to go to 1 penalty phase. We have a great shot, given your mental mitigation, of getting a jury recommendation of life. Let's take that. Mr. Long understood that, and on 2 separate occasions he indicated that he was fine and understood that and wanted to do that.
What's the status of the Pasco case?
This court ultimately found insufficient evidence on appeal from that case.
Insufficient.
Insufficient, yes, correct. And that was based on the carpet fibers. And I don't know the evidence. Counsel representing him in Pasco, I'm sure he knows the evidence better as to what was there. But I don't know that it's a mirror image. What was in Pasco is the same evidence that Hillsborough had. In fact, I don't know how you could know that.
I mean, that's the only thing. I mean, again, and you look at this, and on one hand you hear there's 8 death cases, but then you realize that really it's him confessing to these other crimes, and you get a little nervous as far as, well, if there was insufficient evidence for Pasco and it was the same, but evidence. So
I don't know that it's the same evidence, Your Honor. In fact, I don't know how anybody can know that on this. That's part of the whole thing of going to a plea agreement months before trial was scheduled in this case. Is the state is at a risk because both sides are weighing their risk.
And
at that
now
point
we're
in time.
30 years. I mean, we're way. Why did this take so long in post-conviction?
Well, Your Honor, there are a number of things that were happening in this case, and I was talking with counsel before we came in here about that, and it started when this case became final. Issues with capital collateral. Regional counsel was getting established, and there were funding issues. There was years of public records litigation. There's been numerous changes in judges, changes in counsel, various things, and it certainly has not moved as fast as it should have. But if there are no further questions, I'd ask that this court affirm the post-conviction court's order. Thank you.
Thank you for your argument. Rebuttal.
I think what's critical that the state was talking about is, yeah, there was a discussion for an hour and then he went and was able to think about it overnight. But the discussion, based on this record, was about the merits of the appeal. Nobody, you can read this record from beginning to end, it was never meaningfully explained to Mr. Long what exactly this waiver meant. We know if you waive the right to appeal the suppression of a confession, that's it, end of story. When you look at the totality of this record, Mr. Long didn't understand that in less than, in a matter of a couple months after he enters this plea, he's writing his...
He just described 3 sets of lawyers advising him on whether to do this plea or not. Is that incorrect?
Sir, the discussion was whether this court would grant the motion to suppress or not, or whether they would change the law just because it's Bobby Joe Long. Nobody, and Mr. Grantham, who was present, Mr. Aldridge, who was present, testified. Nobody talked to him about the meaning of a waiver and what that meant.
Didn't
Nobody.
Long have 118 IQ?
Pardon me?
Wasn't his IQ 118?
Yeah, I'm pretty high IQ, but till I went to
He
law
didn't
school, I don't
understand
know what the waiver of an appeal is.
Come on.
I'm serious. As lawyers, we see this day in and day out.
Okay. I agree.
I mean,
We see it day in and
we see this day in and day out. You can waive a suppression issue on tangible evidence and appeal it, but you can't do it on a confession. There's attorneys that don't understand that you can't preserve a confession for appeal, that you better go to trial if you want to appeal confession. Attorneys plead people and say, I want to appeal my confession.
Why was he, it was the day he had been allowed to withdraw it, and he's spending the next day talking about the merits of the suppression issue. If that wasn't relevant to whether he was going to replead or not, why was he discussing it? In other words, it doesn't seem logical that he wouldn't understand that that's why he was calling this attorney up in the resource center. He was trying to figure out whether there was merit to the appeal. Isn't that what he was doing?
And his testimony was ultimately the only reason I told the judge that I would keep the plea is because I knew I was going to get a new lawyer. I would talk to the new lawyer about withdrawing the plea, and then the condition for him getting a new lawyer was you can't do it. And if the court wasn't concerned about there being a potential legal basis to withdraw the plea, why would the court make him waive that right? Why would the court make him waive that right? It should have been dealt with back then. Bottom line, Mr. Long, to this day, has been fighting, trying to withdraw that plea because he didn't understand what he was giving up. And look at Craig Aldridge describing what capital attorneys should do to make sure their clients understand these things. Judge, I'm sorry. We deal with this every day. It's second nature to us. We really don't know. I wish I had a nickel for every time I walked out of a plea colloquy with a client and they're like, what just happened? They're in a daze. They're in front of...
Your time has expired. Thank you for your arguments.
Thank you very much, judges.
The next case of the day is Roberts versus State of Florida. You may proceed.
Thank you. May it please the court, I'm Bruce Jacob, representing Dwight Roberts. Roberts was convicted of 2 crimes which took place in Pinellas County on September 14th, 1991, as part of the same criminal episode. Those crimes were robbery and attempted kidnapping. He was sentenced as an habitual violent felony offender, and to be sentenced as a habitual violent felony offender, there had to be a predicate offense within the previous 5-year period. In his case, the predicate offense was aggravated battery, which had taken place on December 27th, 1990. So the principal offenses were the robbery and the attempted kidnapping, which were committed on September 14th, 1991, and the predicate for the habitual violent felony offender sentences was this aggravated battery, which was committed on December 27th, 1990. The sentence imposed for the robbery was 40 years, with a minimum of 15 years for being an habitual violent felony offender, and the sentence for the attempted kidnapping was 30 years, with a minimum of 10 years because he was a habitual violent felony offender, and the sentences were to run concurrently. There was a problem with these sentences. The statute that allowed the aggravated battery to be used as a predicate offense, which was Chapter 89-280 of the laws of Florida, was unconstitutional during a 2-year window period between 1989 and 1991 because it contained 2 subjects. The petitioner's aggravated battery, which was the predicate offense in this case, was committed on December 27th, 1990, right in the middle of that window period. Florida cases, such as State versus Johnson.
But I thought, let me just make sure, I thought that the important date for whether he gets the HVFO designation is the robbery and attempted kidnapping on September 14th, 1991, correct?
Yes.
That's the important date.
That's the important date. For our purposes today, that's the important date.
All right, but to try to get to this is appreciate your advocacy on Mr. Roberts' behalf. Apparently, we have Johnson that says when the window period closes, because when we have a single subject violation, it's a constitutional violation that we honor so that we want to prevent log rolling. But when the legislature reenacts through their then the biennial process, the window period closes. So it's a very different issue than if we're talking about, in my view, the effective date for ex post facto or other potential constitutional violations.
Right.
Your argument is that this new act, the biennial reenactment, didn't become law until it was published by the Secretary of State?
Published by the Secretary of State.
And that could happen, and it's interesting. That could happen, really. It's the Secretary of State that controls when this thing gets published in an actual published volume, right?
Yes, in those years.
And that doesn't seem like to have the Secretary of State control when the window period closes. Doesn't make a lot of sense to me. Tell me why it makes sense to you.
It makes sense because the legislature wants that to be the effective date, the date of publication, because that gives maximum notice to the public, to the legal public.
Could I ask one question? As it seems to me, this turns upon the issue of published. And is there a distinction between published and printing? Because I understand it. Your position is that it's not until
publication. The printing.
It's not until this book comes out.
That's right. When that book comes out.
However, before this book comes out, the whole state has available through publication Florida session laws. Do we not?
We do, but the session laws are not organized by subject matter. They're
well. Wait. That's a different subject.
Okay.
I mean, the question. I mean, we're talking about when something is published so that the citizens have notice.
Right.
That's not the question of how it's organized or all that. The question is, when does it hit the streets?
That's right. When it's disseminated to the public.
So that's why, to me, I'm troubled by whether this really is a printing rather than first publication. This is the official printing for the state of Florida. It is the official publication. Or you tell me why I'm wrong. Why is not the official publication the session laws, at least the session laws?
Well, the session laws are published, but in the law which was passed by the legislature curing the defect in this case, in the law itself, the legislature said we want this to take effect upon publication. of the law, of the Florida statutes, not the session laws, but the Florida statutes.
What
So
is-
the legislature has specified that they want.
Well, the session laws are Florida statutes. They just have session numbers rather than a statute number, don't
The
they?
1991 Florida statute specifically says in the statute, the 1991 Florida statutes, which are the book that comes out in December, at least in those
Right.
days, it came out in December, not the session laws.
Here's the problem that I'm still having. Legislature many times says this will become effective October 1st. That's usually a date.
Right.
And you're talking about an issue of when the citizens have notice. But that's why I want to, again, to me, if we stick to the reason that we find a law unconstitutional based on a single subject violation, it's because we want to make sure the legislature part of the legislature didn't hoodwink the other part into passing something because it's multiple subjects. So when the session ends when it was biennial, by reenacting the law, not repealing the law, the log rolling defect is cured. And to me, that's why this case we don't need I think some of the issues is when is there notice to the citizens of a law? I didn't know it when I committed the crime. Could be different. But for this purpose, for the court deciding when the window period closes, the relevant date, from my point of view, is when the legislature finishes its business in that biennial session and reenacts the law, because then there's no question that the half of the legislature that may have been hoodwinked, they're no longer, it's now separated into subjects. So why does it have to be the same for everything for us to decide that what we said in Johnson, although we may have used different words, was the correct law, which is that it was cured as of May 1st or 2nd, 1991.
Well, when the reenactment
Do you
statute
understand what I'm saying about the different purposes, though, that is between when the notice or an ex post facto law or,
Right.
the ordinary citizen versus curing a single subject violation? Do you, first of all, accept that there could be different dates or not?
Well, it really comes down to when is a law? And when the legislature at the end of the session passes a reenactment statute, is it really a law? No, it's not.
But that's why
It's
I'm
a future law.
But that's why I'm saying they're curing the single subject violation. That's what
Right.
it's not really when does a law become a law, it's when does the violation become cured. At least that's how I'm seeing this case. And why am I wrong about that?
Well, I think my answer would be that it's up to the legislature to decide when that takes place. And the legislature, very specifically in the reenactment statute, says we want this to become a law.
No, but the legislature in this case actually wanted it to become a law 2 years before. They didn't say, the court's the one that said there's a single subject violation. Legislature passed a law that they thought was valid.
But it was unconstitutional. It wasn't
Well,
valid.
unconstitutional on, we haven't had these in the last 10 years, on something that is a constitutional technicality. Okay, it's important, but it's about whether, so they said we wanted it 2 years ago, and now we want it again.
By the way, these issues still come up. The Environmental Confederation case that's cited in our briefs is a 2003. These issues are still coming up, so this is not a dead issue. Even though this
And I
occurred
think the
back
legislature definitely needs to look at when they say it becomes effective on publication,
Right.
and know that, especially in this day and age, when you have the internet, when you have laws available like the day they're passed, whether you really want to have publication, as Justice Lewis is pointing out, that book be the time that a law becomes effective. So I
the
agree
legislature
this is
could say, and they did in a statute that was cited by the state, Chapter 2003-27, the legislature did say in that statute that this shall become effective as of the time the governor signs it or it becomes law without his signature. So the legislature can do that.
But in this case, however, once it was sent to the Secretary of State's office, didn't the public have access to that statute?
If someone is curious enough to write or call in or go to the Secretary of State's office to find out, yes.
But
then-
if you're not curious enough to even look in the statute books or the laws of Florida book, you still wouldn't know. If it's available
Right.
for the public, why isn't that publication?
Because it's not broad enough, it's not widespread enough publicity, it's not broadly disseminated to the public. The public in general doesn't have full access to it.
But then that would apply, if you took your argument to its logical conclusion, it seems to me, that would apply to any statute, even if the legislature says this becomes effective October 1, but if the books are not published until December, it's not widely disseminated until December.
If the legislature said it should become effective on October 1st, obviously that's the date it's effective. In this case, that's not what happened, though. The legislature said this reenactment shall take effect as of the time of publication, which we know was in December in those days. Today, I think it's October when this
Publication of
happens.
that particular statute book was in December.
Yeah.
We accept that. But as Justice Lewis pointed out, the session laws were published before that,
Yes,
and those are available to the public.
but they're not organized by subject matter. It's more difficult to find what you want in the session laws. And if the legislature wanted the session laws to constitute the effective date, or wanted that to be the effective date of the reenactment, they could have said so, but they didn't in this case.
Well, the thing that concerns me a little bit, I'm trying to put the logical progression of the argument, because we know that the legislature places different times on different statutes.
Right.
And if we're saying that there's no notice until this comes out, then none of those, I mean, you're going to be subject to constitutional challenges to virtually every statute that's there, even if they say some other day, because the public doesn't know about it.
It's not that there's no notice. There's some notice, but if the legislature wants maximum
Wait a
notice...
minute. I mean, this is a concept. I'm not sure that there's such a thing as some notice, not notice. I mean, we either have notice or we don't. I mean, it's not like, don't we? I mean, in the constitutional context, for a sufficient notice of a law.
The legislature decides how much notice they want, and if they want maximum notice, they would set the date at the date of publication, which in this case was December. Now today, I think it's more like October, that the statute book that you have is published. But
What do you believe to be the best case that you would provide us, that would give us guidance, that would say that notice when the statute says publish means this Brown book, not session laws, not any other kind of publication?
Well, there is the one First District case that we cite, the Environmental Confederation case, in which the court said
that you think is the best reason
that's
case?
that's the only case I can think of offhand.
Let me ask you as to the specific date, following up on Justice Lewis's and Quince's questioning as to the laws of Florida. The state says that the laws of Florida, with the 1991 amendment, was published, printed, and available to the general public on August the 27th, 1991.
Mm-hmm.
Do you agree with that?
Yes. Yes, that was the date of the publication of session laws. But as I
So if we accept that as the published date, then the state wins in this case, right?
no, because the statute, the reenactment statute, doesn't say session laws. It says the laws, the Florida statutes 1991, which are the set of books, which is the set of books.
If we interpret the statute as saying upon publication, we agree with the state that the publication occurred on August 27, 1991, when the laws of Florida was published.
Yeah.
Then the state prevails in this case.
Yeah, they would if you take that position. Yes, you're right about that. Anyway, in our case, the predicate crime clearly took place within the window period of unconstitutionality. The principal cases, of course, the issue here is whether the principal offenses, which took place in September 1991, also took place during that window period. And
But let me make
Go ahead.
sure you're not argument that because the predicate offense occurred within the window period that you have a problem. That's not
Well,
a
that's
part of
clearly-
your argument, is it?
clearly, it took the predicate. No, the cases such as Thompson and Johnson say that if the principal offenses took place during the window period of unconstitutionality of the aggravated battery, then the defendant should be entitled to go back for resentencing. Clearly the predicate offense took place during the period of unconstitutionality. The only question is whether the September date of the principal offenses either occurred after the closing of the window period or before. Of course, we say that the period closed in December. States that says that it was either May or August. So anyway, that's the issue. Let's see what else I have here. So really what it comes down to is whether the intent of the legislature in setting the date of publication of the Florida Statutes 1991, which was in December, is the date on which this window period closed. And we say that, our argument is that the legislature is in control of deciding when a law becomes a law, when a law takes effect. And in this case, they clearly have said that this law should take effect, this reenactment should take effect at the time of the publication of the Florida Statutes of 1991. The state argues that the session law should be sufficient, but that's not what the intent of the legislature was in this case. They did not say the date of publication of the session laws. They did not say at the time the governor signs. Instead, the legislature said the date on which the reenactment occurs is the date of the publication of the Florida Statutes 1990.
Is that actually what it says?
Yes, that's what the law says.
It doesn't say upon publication. It says upon the official state of Florida 1991 Florida Statutes.
1991 Florida Statutes. Upon publication, 1991 Florida Statutes. It doesn't say session laws. It doesn't say on the date the governor signs the bill. And our position is that under our Constitution, it's the legislature that decides or should decide when a law takes effect.
And you don't again, going back to the argument, I see you don't think that the issue for us, because, and going back to that it's a single subject violation, and when it's cured, that we don't have to get into if somebody else had committed a new crime, whether it was between the session law and the Florida statutes, there might be a different answer?
If somebody's crime was committed in January of 1992, then obviously their crime would have occurred after the end of the unconstitutional window period. But since September falls within the window period, our argument is that our client should go back for resentencing.
You are in your rebuttal time.
Okay. I just want to close by saying that the answer to the question, which was referred to this court by the Second District as a matter of great public importance, the answer is that to that question, our position is that the answer to the question is that the annual or biennial reenactment becomes effective upon publication when the reenacting legislation specifies that law should take effect immediately upon publication. Thank you.
May it please the court, Assistant Attorney General Timothy Freeland here on behalf of the state of Florida.
Could you answer one question as we get started?
Yes, sir.
Do you agree that back then, that when the statute was passed, that the legislature used the words that this shall become effective when the 1991, this language, 1991 Florida statutes are published?
No, sir. I do
it
not
doesn't
agree.
say that, does it?
I'm looking at Chapter 9144, which was published in
says,
Laws of Florida. It refers to Florida Statutes 1991, but in making reference to that, they're describing how it should be cited and what the title of the book should be when it is eventually printed.
Well, it says, let's just read let's read the exact language.
Yeah.
It says, is adopted and enacted as the official statute law of the state under the title of Florida statutes and shall take effect immediately upon publication. Said statutes may be cited as the Florida statutes. Now, again, I have a different take on this, which is about when the single subject violation is cured. But if we were talking about when a crime, ex post facto issue, it sure looks like it is upon publication of the Florida statutes, which are, as Justice Lewis was holding up, the bound volumes that separate things into chapters, not the yearly session laws, which are just the laws passed that session. So that looks like a term of art to me, and it's that the legislature uses. How is that? Can you construe that language as meaning the Florida session laws?
Well, I actually, to be honest, I don't construe it as being the Florida session laws. That's an alternative argument that we advanced in our brief. But the initial argument that we're advancing is that publication occurs when it is received by the Secretary of State's office. When
So
the
that's
legislature.
the date that we used in Johnson.
Correct. Now, if we look at.
But that's a good, I mean, that is a good I mean, obviously, to me, it fulfills the purpose of curing the single subject violation.
Correct.
But I'm concerned about that as being a general principle as it might apply to somebody committing a crime that was not just being cured by the single subject violation. When the legislature is very specific, I mean, isn't it up to the legislature to either say it's October 1st or you give a date, it's 60 days after, if it becomes law upon there. But when they use the word publication,
we're still down to determining what do they mean by publication. And what I would
well,
suggest.
why should we be? In other words, this is something, it seems to me, going forward, especially with the internet and everything being available, that we ought to be telling the legislature and their staff, fix this problem so we don't have to be guessing.
Well, every court that has examined this specific chapter law, 9144, has concluded that it took effect on the date which is contained within the chapter law at the very end. If we look at the end of it, it says, became a law without the governor's approval May 2nd, 1991, which was on or about the day it was received by the Secretary of State's office.
But that's not publication. It's
It is from our point of view.
Huh?
It is from our point of view.
You see, it just seems that to stretch the word publication and maybe end up in another case with unintended consequences, why couldn't we hold in this case that, again, for curing a single subject violation, we meant what we said in Johnson, it was cured as of May 2nd, 1991.
Part of the reason why I say that publication does not necessarily mean the same thing as printing, I look at the dictionary definition. Webster 3 says that publication means, the very first definition they give in Webster 3 is publication means made public. And that's our position, that this law was published once it was received by the Secretary of State's office and made public.
So even before the session laws came out?
Yes.
Well, the Secretary of State received it May 1, right?
Correct.
And then it says that it became a law without the governor's approval on May 2nd.
Correct.
So which
You're asking
date
why?
are you saying that it became law?
If we look at the public records, and I recognize that this is not before the court, but if the court chose to look at the public records for the legislature, we would see that that was the date, May 2nd, that they received notice from the governor's office that Governor Childs had in fact sent this
And that's
document
because the Secretary of State had it because of the filing the day before.
Right.
And then once they had it, by the governor not signing it, it became law the next day. Therefore, it became published as a law because they already had it that day? Is that your
The
argument?
legislature chose May 2nd because that's the day that it's published in the Journal of the House of Representatives. That's the day that they received notice from the governor's office that this document, this chapter law, had been delivered to the Secretary of State's office. That's true in Chapter Law 9144. If we look at Chapter Law 9797, we have similar language in 9797. And this court, in Tormey versus Moore, in Salters, 2000 case, and Xavier Trapp, another 2000 case, interpreted this chapter, 9797, as taking effect on the day that it was received by the Secretary of State's office. Again, in that chapter law, 9797, at the end it says became a law without the governor's approval, May 24th, 1997.
My problem with it, and again, is that I think it's a strained reading of publication to say that when the Secretary of State received it, it was published as the Florida statutes. And the legislature, in other situations, they know how to say this statute will become law on October 1st. they obviously have a reason when they are reenacting through biennial process, which they did up till when it was then annual, to use it for that purpose, the publication of the Florida statutes, because as Mr. Jacob stated, that's when it's put into its nice chapter format, and you don't have to be looking for it under, just that year. So really, the legislature can control what it's going to say when it's either reenacting, and I just think that when it's a biennial reenactment, the idea that they didn't mean it to be for whatever other purposes publication when it became the Florida statutes, I think it's a strained it's strained to give it publication another meaning. So why is it that we would have to take publication and kind of turn it on its head in order to decide this case favorably to the state?
Well, honestly, I don't think that we are taking the term publication and turning it on its head, because referring to the dictionary definition, that one of the things that if, for example, I'm in court and I want to... You think
that most people think that publication of something as opposed to notice to it means notice to the public?
I think that's what the legislature thinks.
Wait, a minute ago you talked about the House Journal, right?
Correct.
What is posted, if anything, on the House Journal when it became law on May 2nd?
There is a notice in the House Journal which says, today the following bills were noticed. We received notice from the governor's office that he had filed the following bills with the Secretary of State's office, and that's on May 2nd. And this bill...
Well, it was filed, but it was filed in the office of Secretary of State on May 1.
Correct.
So what happens on May 2nd?
May 2nd is the day that the legislature found out that it was filed with the Secretary of State's office, and they chose that date as the day which they believe it was actually published.
But is there any notice in the House Journal that that it became law without the governor's approval?
Yes, it says that in the House Journal. On that day that it became a law without the governor's approval, he filed it with the Secretary of State's office, and published then, in this sense, means published in the House Journal.
So why wouldn't that be the first date of publishing?
You mean May 2nd?
Yes.
That is what in fact happened.
And the publishing occurred then in the House Journal.
Correct.
The problem, again, and I appreciate what you're saying, and I want to get there, believe me, this is that the statute says is adopted and enacted as the official statute law of this state under the title of Florida statutes and shall take effect immediately upon publication. Such statutes may be cited as Florida statutes. No one's going to be able to cite to Florida statutes until the Florida statutes are actually published in print.
True, but citation and publication obviously are not going to be the same thing. When they actually come out, eventually we'll cite to them.
What's the definition of publication that you're relying on again?
From Webster 3, publication means the act of making something public, or by proclamation is publishing. If, for example,
But you're basically taking the position that when something's filed.
Just like when you sign an order, it's not official until it's rendered with the clerk's office. When the legislature and the governor gets done with their business, it's not official until it's filed with the Secretary of State.
That's a very unusual understanding of what the term publish means, it seems to me.
Your Honor, when I'm in court and I publish something to the jury,
well, they're right there. They see it.
Correct.
I mean, you're talking about something that gets filed in an office up here. Now, obviously, there are circumstances where people are on constructive knowledge about things that get filed in certain places because they got a duty to go look them up. But that's a different question, it seems to me, than what published means.
Well, if we're talking about a single subject rule violation, the reason why it's a single subject rule violation is there's a possibility that there was some kind of confusion in the legislature when the bill was passed. Because the way the legislature does these things, they cite the title, they don't necessarily read verbatim the exact entire bill in the legislature. It passes the legislature, and then it is sent over to the Secretary of State's office. In this case, Chapter 89-280 was sent to the Secretary of State, and then it was printed in the statute books for 1990. A supplement for 1990 came out containing this law. So the public has this law in their possession. Even though this court had found it was unconstitutional, the subject matter, the specific language of the law was already in the hands of the public. All that was required for that law to be actually effective is for it to be reenacted by the legislature. We
Well,
already
that's
knew
a
what the
different,
law
see,
said.
maybe I feel like we're talking over one another. That's what I thought I was saying to Mr. Jacob and to you, which is that when the legislature finished its business and the governor, it became law when the governor did not veto it, that's cured the single subject violation. I don't understand why the state is insisting to get there. We have to come up with a strained version of publication, not when something's published, publication that could have a adverse effect in some other case because a different right is being involved.
Well, number one, Your Honor, every single time we've had an issue dealing with reenactment in a single subject rule violation, this court and other courts have used the date identified by the legislature in the laws of Florida as being the window.
But we've never interpreted the word publication. In other words, this is sort of a novel argument that I must say it was very fascinating to look into this, and I hope I never have to do it again, is that we assumed what I'm saying today, which is when it became law, when the governor, didn't veto it, and it's a sort of and the legislature finished its work, so they weren't going to repeal this law. Right. So the single subject violation is cured. That is different than when a law becomes, when the statutes are available for publication, or that there's a publication of the Florida statutes, which did not occur until December.
The official law, the actual official law that is available to the public is what is contained in the Secretary of State's office. They are the archive of the official law. The statute book that comes out, there have been numerous occasions where the statute book, the Brown book that Justice Lewis has in front of him, contains errors. Which law do we rely upon as being accurate then? The one that is
We're really talking about
published?
effective date, and the legislature can pick, not when, the publication has to, again, that is a very interesting thing, but for us, when the legislature says this new domestic violence law will become law.
Upon publication.
No, they don't say that. They say effective October 1st.
Then they've specified a date.
It's either usually July 1st or October 1st. I've never had a situation where looking at the date that something's becoming effective as being worrying about when the Secretary of State gets around to printing the Brown volumes as being relevant to our discussion.
That seems to be a strained interpretation, to consider that the Secretary of State's office might control when the legislature.
Well, that's why the legislature maybe next time it does one of these should be a little clearer on what they mean.
I think they are clear, though, if I may, because when the chapter law 9144 comes out, the legislature makes a notation exactly what they mean by effective upon publication, because it says became a law May 2nd, 1991. That doesn't come from the Secretary of State. That doesn't come from the Attorney General. That comes from the legislature.
And what are you reading
there's
from
a
there?
distinction. There's a distinction between something becoming a law and something becoming effective as a law, isn't there?
Yes.
Well, that's a pretty fundamental distinction. I mean, you're trying to combine those two things. And it seems like here the legislature has said that this will be effective as a law when it's published, and that's a separate question of when it became a law. And I understand that that's a pretty formalistic distinction, but I think it's part of the framework that we work within, isn't it?
It is. The legislature determines when the law is to take effect. They announced in this case that it should take effect upon publication. So we're back to that question of what exactly do they mean by publication. And I would suggest that when they say that it took effect, became a law on May 2nd, that is what they mean by that. And that's a consistent thing that they do.
If they'd said effective, if they'd said it became effective on that date, maybe that would be different.
Perhaps it would.
But they didn't
Perhaps it
say
would.
that.
The alternative argument, if the court doesn't.
Of course, we've already said that.
True. We have. The court has said it several times in Tormey versus Moore, in State versus Johnson, in the Salters case.
Well, the point is, we said it in State, I mean, the easiest way, we said it in State v. Johnson, which is the issue involved in this case.
Correct, and also in Tormey versus Moore, which was addressing the same chapter law, although a slightly different issue.
But we didn't have all the edification we got from Mr. Jacob about the nuances.
The way things work.
Where'd you get the August 27, 1991 date for the effective date of the laws of Florida?
I got that from the same source that Mr. Jacob got from Ms. Healy, who was with the
You see, that also gets me nervous. In terms of using any of these dates, August 27th or December, we're relying on a person in the, it's not
Right.
even official record.
Which is
We're
why
relying on an email?
I think I urge the court to go with the date that is contained in the chapter law, because that evinces the best explanation of what the legislature means by effective on publication,
You mean it May 2nd?
the May 2nd date.
But we're having problems, or at least some of us, with this strained idea of what publication means.
I understand. I'm done with my argument. I would just urge that the court affirm the second district. The proper determination here should be that the law took effect on May 2nd, the day on which it was, in fact, published in the Secretary of State's office. Thank you.
Thank you. Rebuttal?
The definition in Webster's for publication, the word publication means announcing, proclaiming, communicating to the public, making a general distribution to the public, disseminating to the public. And of course, that day we say it was December 30th of 1991. I think we really have to strain to reach the conclusion that publication occurs when the Journal of the House of Representatives or the Journal of the Secretary of State's or some records in the Secretary of State's office reflect that the law has been passed. We say that a bill has become law when the governor signs it or when the governor allows it to become law without his signature, but we really don't mean that. That's just a term of art. It's a figure of speech. It doesn't become law at that point. It becomes future law. It becomes law when the legislature says it should take effect. Until that time, it's not law at all. It's a law that's going to take place in the future. The District Court of Appeal below said that it was bound by the language of State versus Johnson to the effect that Chapter 89-280 was reenacted and also became effective on May 2nd, 1991. But the May 2nd, 1991 date was not the effective date. It was a mistake. I'm not sure why they said that. It was a mistake. It wasn't May 2nd, 1991. The effective date, as was stated in Chapter 91-44, was the date of publication of the Florida Statutes, 1991.
Let me ask you this. If I committed the offense before any offense that was committed before December, you're saying would mean that the aggravated battery or aggravated battery, is that what it is, could not be the predicate offense.
That's right.
Any offense that a defendant committed before the December whatever date you allege it is.
That's correct. In cases like Thompson, your Thompson case, Johnson have said if the principal offenses occur within that window period of unconstitutionality, then the case should go back to the trial court for resentencing.
Statute, despite the reenactment, remained unconstitutional until December 30th.
That's
that
right,
is
until the reenactment
the
took
essence
effect.
of your argument.
That's my argument. Yes.
You're out of time. Thank you for your
Thank you very
arguments.
much, Your Honors.
The court will be in recess for 10 minutes.
Thank you.
All rise.
you.